Great. Good morning, everyone. Welcome to the July 10th, 2026 regular meeting of the San Francisco Ethics Commission. Today's meeting is live cablecast on SF.gov TV and live streamed online at sfgovtv.org/ethicslive. For public comment, members of the public may attend in person or may participate by phone or on WebEx platform as explained in our agenda document. Clerk, would you please explain how remote public comment will be handled?
Certainly. Public comment will be available on each item on this agenda. Each member of the public will be allowed 3 minutes to speak. For those attending in person, opportunities to speak during the public comment period will be made available here in room 400 at City Hall. For those attending remotely, the public comment period can also be provided via phone call by calling 1-415-655-0001 with access code 2660-152-5470. followed by a pound, and then press pound again to join as an attendee. When your item of interest comes up, press *3 to raise your hand and be added to the public comment line. Public comment is also available via the WebEx client application. Use the WebEx link on the agenda to connect and press the raise hand button to be added to the public comment line. For detailed instructions about how to interact with the telephone systems or WebEx client, please refer to the public comment section of the agenda document for this meeting. Public comment may also be submitted in writing and will be shared with the Commission after the meeting has concluded and will be included as part of the official meeting file. Written comments should be sent to ethics.commission@sfgov.org. Members of the public who attend the Commission meetings, including remote attendance, are also expected to behave responsibly and respectfully. During public comment, please address your comments to the Commission as a whole and not to an individual member. Please, people who engage in name-calling, shouting, interruptions, foul language, or other distracting behavior may be excluded from participation.
Thank you, Clerk. I now call the meeting to order. Clerk, will you please call the roll under item 1?
Certainly. Chair Forrest Fang.
Here.
Vice Chair Salahi.
Here.
And Commissioner Francois. Here. Chair Forrest Fang, with 3 members present, you have a quorum.
Thank you, Clerk. And I want to note for the record and for everybody who's here and online that because some commissioners have excused absences, we're going to take one item off the agenda, and that's specifically item 12. That one would require 4 votes to be approved, and so given that we don't have the sufficient number, we are going to take it off the agenda and move it to a later date. With that, I call agenda item 2, general public comment. Does anyone here today wish to give public comment?
Yes, good morning, Commissioners. My name is James Chafee. I should be able to ask if you were going to follow your bylaws. I suppose it would be a rhetorical question. It is of the essence that it should be a practical question. I filed a sworn complaint with this Ethics Commission, and on the 26th day, I got an answer by email. I made the mistake of putting email on my letterhead. I got in that email, the notice said, you may provide additional information, evidence or information you have regarding your complaint to me. That's a direct quote. I replied with a question about what it means to have a sworn statement with statutes which are designed to expedite a sworn statement if it takes 26 days to even pick it up and give it a number. I don't get an answer to that, but 2 hours and 20 minutes later, I get notice that my case has been dismissed. You notice that if it's detrimental to the public, the delay takes 26 days. But if it's detrimental to the public, it only takes 2 hours and 20 minutes. The reply does give some notice. He claims that there is no evidence of willfulness. Well, that's preposterous. It's willfulness on somebody's part. And in fact, in the old days, before there was an ethics commission, the city attorney would take up complaints like this, and they would send a strongly worded letter to the perpetrator saying, there's no evidence of willfulness right now, but we take these violations very seriously. The other thing he says is that you can refer this to the Sunshine Task Force. Well, that's preposterous, too. The Sunshine Task Force has taken up this numerous times. I filed an actual complaint against this same perpetrator in 2005. Normally, the history of the perpetrator would be assessed as part of a determination of willfulness. But that doesn't seem to be the case in this situation. Actually, he's probably not read the complaint. He's not doing anything but seeing how I'm treated in front of the Ethics Commission and decides, well, if the Ethics Commission doesn't pay any attention to these jerks, why should I? And there's a number of other issues. Should I continue?
Your time has expired.
Thank you.
Thank you for your comment. Anybody else in the room who'd like to give public comment? Okay, clerk, anyone in the queue?
Checking the queue to see if there's any callers on this item. One moment. Looks like we may have 2 callers for public comment. One moment while we connect them. Good morning. Can you hear us?
Can you hear me now?
Yes.
Yes. Go ahead. Your 3 minutes starts now.
Okay. The caption on the screen is item 1, call to order and roll call. Are we actually on item 2, general public comment?
We are.
We are.
Okay.
And that would actually be SFGov that's controlling the content across the screen.
Okay. So on item 2, good morning. This is David Pilpel. I'm not feeling great today, but I have some comments on items 9 and 11 on today's agenda. Before we get to item 11, I note that item 11 refers to a closure letter from DHR, which is not included in the agenda packet, nor is any public correspondence. I recall that there was public correspondence last year, last time this item was at the commission. Finally, there was no prior notice of the regulation or the proposed regulation amendment pursuant to Charter Section 4.104A1. See also the City Attorney's Good Government Guide, page 23. I think this failure to provide the 10-day advance notice of a regulation amendment is fatal to hearing the item today. Thank you very much.
Thank you for your comments. Chair, one moment. It looks like we have 1 additional caller for public comment. And we'll let them connect.
Hello.
Welcome. Your 3 minutes starts now.
Sullivan. I will read a part of the Sunshine Ordinance, but similar language is found in the Brown Act 54957.5. Section 67.7, Agenda Requirements and Regular Meetings. B, a description is meaningful if, skip words, it shall refer to any explanatory documents that have been provided to the policy body in connection with an agenda item, such as correspondence or reports, and such documents shall be posted adjacent to the agenda. I submitted on April 25th, 2025, a written comment on the subject matter of today's agenda item 11. Nowhere on agenda item 11 is it referred to. Keywords are shall refer to any, meaning all documents and correspondence. Looking at this agenda item and other agenda items, there appears to be documents missing. In the Brown Act, this is called an agenda packet. The purpose of including all records pertaining to an agenda item is the people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments they have created. The Brown Act 54950. Also see Section 67.9, Agendas and Related Public Materials, Public Records. Even on every Ethics Commission agenda under written public comment says public comments submitted in writing shall be included as part of the official meeting file. Thank you for your time.
Thank you for your comments. Chair Flores-Fang, we're checking the queue to see if there's any additional callers.
Thank you.
And it looks like there are no additional callers for this item.
Thank you. Any commissioners who wish to provide general public comment? Okay. Okay, I will now close this item. I now call the consent calendar. Colleagues, as noted in the agenda, there will be no separate discussions on the consent calendar's items unless a request is made by any of us or a member of the public in attendance, in which event the matter shall be removed from the consent calendar and considered as a separate item. Does anyone wish to remove an item and discuss it separately from the consent calendar?
Yes, I would like to request that the commission take up the approval of the minutes. Is this an occasion for 3 minutes of comment, or?
Mr. Schaefer, they're speaking between themselves. We'll have a moment for public comment regarding the consent
That's
calendar.
my question. Obviously.
There'll be a moment for you to speak. They'll call you up.
So unless there's any commissioner who wishes to take anything off calendar to discuss separately, I welcome public comment. And so now would be the appropriate time. Thank you.
So you're taking up the approval of the minutes now?
Well, we agreed to take it off calendar, and so I can call it afterward. But if there's anything else, if that's all you'd like to take off calendar, we can do that. I just wanted to make sure that was all you wanted to take off calendar.
So this is not approval of the minutes?
Correct. Yeah. Thank you. Okay, if there is anybody in the queue who maybe wants to comment about taking something off calendar, and then we can discuss that once I call it.
Chair Flores-Fang, checking the queue, and it looks like there are no callers to speak on this item.
Okay. So hearing no further discussion, I am going to move to adopt the consent calendar, but remove the discussion of the minutes. And I think that is item 3. Does anybody move to adopt the consent calendar except for item 3?
So moved.
Seconded. Clerk? I second. Great. Clerk, will you please call the roll?
Certainly. On the motion to adopt the consent calendar with removal of item 3, the meeting minutes, Commissioner Francois? Vice Chair Salahi?
Aye.
And Chair Flores-Fang?
Aye.
And
Aye,
Chair
now-
Flores-Fang, with the 3 votes affirmative, the motion passes.
Thank you. I will call item 3, which are the draft minutes of the regular meeting. Does anybody wish to give public comment?
Yes, thank you very much. I have, over the past several months, submitted 3 printed letters to your offices. I've also exchanged emails with your staff, only a few, but some. Yet, in these minutes, my surname is misspelled. I get the message. Believe me, I get the message. There is a provision of the Sunshine Ordinance which requires that if somebody submits citizen summaries of their comments that are less than 150 words, they shall be included in the minutes. That's 6716. I submitted 2 summaries of my comments. back at this April 10 meeting, and I submitted summaries. I requested formally a public document request for these minutes and received the minutes, identical apparently to the ones that are in your agenda packet, that do not include any summaries at all. However, that's a little bit of a misdirection, because on the second page, there is a line that says you can view a copy of his written public comment here. And the word here is underlined. It has no indication of what here is supposed to mean. Now, if I have a computer and a browser and an internet connection and a public document format reader, I can click on that here, and it's a sort of hot button which introduces or opens a separate document. Now, I don't take the word include and opening a separate document to be the same thing. Yet the point of this ordinance, section in the ordinance, is to allow people to represent themselves and have it be contiguous. Now, not only do we want to include all of the people that don't have all of those things to find out what here means. Democracy means that we include a wide spectrum of people, not a narrow section. Still, I expected that the Ethics Commission would represent a model of how to interpret that section. You've been interpreted this by the Sunshine Ordinance Task Force. Okay.
Thank you for your comment. Anybody else who'd like to give public comment?
Chair Flores Fang, checking the queue to see if there's any callers.
Thank you.
And there are no callers on this item, Chair.
Any commissioners who wish to give comment on this?
Just a question, really. Do we have the ability to attach Mr. Chafee's public comment to the minutes?
Non-electronically?
Right.
I can add it at the very back of it, yeah.
Thank you.
Mhm.
Yeah. I might move to adopt the minutes with correction to the spelling of Mr. Chafee's name and attaching, reproducing the written public comment to the minutes.
Seconded. Clerk, would you please call the roll?
On the motion to adopt the meeting minutes with the change of adding a physical copy behind the minutes of Mr. Schaefer's letter. Commissioner Francois?
And also to correct.
And also to correct, yes. And Commissioner, Vice Chair Salahi?
Aye.
Chair Flores Fang?
Aye.
And Chair, with 3 votes in the affirmative, the motion passes.
Great. This item is now closed. Okay, I now call agenda item 9, which is the show cause hearing in the matter of Rick Sanders versus Officer of the Mayor, Sunshine Ordinance Task Force file number 25088. This item is being called in connection with a May 5th, 2026 referral of the matter by the Sunshine Ordinance Task Force to the Ethics Commission for enforcement proceedings under Section 67.35D of the Administrative Code for failure of the office of the mayor to comply with an order of determination issued by the Sunshine Ordinance Task Force on February 4th, 2026. Section 10B of the enforcement regulations requires the Commission to schedule a show cause hearing upon receiving a referral from the Sunshine Ordinance Task Force and to provide at least 15 calendar days notice to the parties involved. A show cause hearing was originally scheduled for June 12, 2026, and a notice hearing was issued on May 26, 2026. However, that meeting was canceled, and the hearing was continued to the next available regularly scheduled meeting of the Commission, which was scheduled on July 10th, 2026 instead. Notices were issued on June 22nd, 2026 to petitioner Mr. Rick Sanders and to respondent Mr. Dexter Dermali of the Office of the Mayor, both of whom were named in the referral. Because we haven't appointed an individual hearing officer, the commission as a whole will serve as the hearing panel for this hearing. As chair, I will assist in the administration of the rules and procedures of this hearing. First, I need to ascertain if the parties are present for the hearing. Mr. Sanders, if you're here, could you please identify yourself? Okay, Mr. Dexter Dormali, if you're here, could you please identify yourself? Thank you. Okay. So, seeing as one of the parties is absent, I believe that this matter may need to be calendared for the next hearing. Is that correct?
Actually, Chair, I just got a notification that Sanders is on the phone.
Okay. Okay. Is there any issue with proceeding in a hybrid format? May I request any advice on that?
Chair, no, I don't think so,
Okay.
as long as the party's here.
Okay, fantastic. Okay, so Mr. Sanders, it sounds like you're here. Could you identify yourself by phone? Or could we allow Mr. Sanders to speak?
Let's connect him. One moment.
Thanks.
Okay.
Welcome.
Hi, yes, I'm here.
Okay, great. Welcome. And although the Sunshine Ordinance Task Force is not a party to this matter, the enforcement regulations allow the task force to send a representative to present comments or arguments in favor of the referral. The commission has learned that the member Bruce Wolf will be in attendance today. Member Wolf, if you're here, could you please identify yourself? Okay, should we check the queue? Are they also attending remotely?
Checking the queue. One moment.
Thank you.
Hello? Can you hear me? Hello?
Yes, welcome.
Yes.
Okay, great. Thank you.
Okay. So we're going to begin with the Sunshine Ordinance Task Force presentation on this matter. Since this matter was referred by them at this time, I'd call on Member Wolf to provide us with any comments regarding this referral. And you'll have 5 minutes, and you'll receive a 1-minute warning.
Okay. Thanks for unmuting me. Thank you for receiving me today. My name is Bruce Wolf. I'm in seat 11, representing with the disability lens to the Sunshine Ordinance Task Force. I just wanted to start off by, first of all, how much time do I have?
5 minutes.
Okay, very good. Thank you. I just want to start off by saying in San Francisco, willfulness regarding government ethics means the purposeful failure to carry out a mandatory duty or a conscious choice to ignore the law. Handled primarily by the Ethics Commission here, willful conduct does not require an intent to break the law or injure another, just an intentional regard for the requirement. And that is what we hold to be the definition of willful. First, I want to say that in this case regarding the referral, the reasons that we found it necessary was that there was documents that were initially told to the requester that there were no responsive documents. And then sometime later, documents were provided. And that is indication for us that there probably is more. And usually, in our experience, that is the case. So when asked many times over many meetings, there was still a resistance to provide any additional documents. And clearly, there were a lot of gaps in the context of the incident to show that there had to be some other documents. Second reason also is that under Smith versus San Jose, considering the context of the complaint around a phone call with the President of the United States, there had to be some information on the actual device that was used for the phone call. And under Smith versus San Jose, there's a requirement to disclose that. And it was provided to us that there were no responsive information to be provided, not even a call log or any kind of showing that there was a call that was received at all, which would be part of what is contained in every single cell phone to show that what the call log is. And so we found that to be a bit unbelievable, that they couldn't provide that. And those two primary incidents, those two primary reasons, we found it to be the mayor to be willful in not providing the information to the requester. And we submit that there may be more information in question that is concealed, and because of the lack of subpoena power that the Sunshine Task Force does not have, the Ethics Commission does have subpoena power and can do the work to request the documents that the Sunshine Task Force believes exists and take testimony under oath. And I'll stop there. Thank you.
Thank you, Mr. Wolf. I also see that the Enforcement Division has provided a memo in connection with this agenda item. Would the Acting Director of Enforcement, Mr. Zumwalt, come provide us with some information regarding the memo? Thank you.
Good morning, Commissioners. Jeff Zumwalt, Acting Director of Enforcement. I don't have much to say beyond what's in the memo. I'll just give refresher on the enforcement authority that the Commission does have over referrals from the Sunshine Ordinance Task Force, and that is limited to willful violations of the Sunshine Ordinance by elected officials and department heads. And to that, the enforcement authority that the Commission would have would be not to issue monetary penalties. It's only the other available remedies in the charter, which is cease and desist and file records, typically for like campaign finance. That's where that provision would apply to. And beyond that, we would just highlight our recommendation that the Commission take no action on this referral. This is consistent with the recommendation we made during a referral last year as well. And that is because with this, it has to be a willful violation by an individual, not a city department. This one, it names the city department. And also that with the changes we're proposing with the regs, as far as whether or not we would handle these again in the future, that's something we're proposing to remove. So if you have any other questions, I'm happy to answer those.
There will be time, I think, for questions a little later. So we'll now proceed with the show cause hearing. The hearing will proceed in the following manner. Each party will have 10 minutes to present their argument with the option to reserve 3 minutes for rebuttal. First, we'll hear from the petitioner, after which we will hear from the respondent. And I just want to make sure that the petitioner is on call. I know that, is that something you can confirm, Clerk, that he'd be on call whenever we can have him?
Yeah, let me double check with SF.gov TV.
Okay. And also just that he can hear me.
Yes.
He can hear me, for sure, yeah. Okay. So we'll hear from the petitioner, after which we'll hear from the respondent, and then we'll have rebuttal arguments, and we'll proceed in the same manner. If parties choose to reserve 3 minutes, they can do so. Witnesses may testify for 3 minutes each, and it's possible for the Commission to extend these timeframes at its discretion. So if parties wish to call a witness, each witness may approach the podium or call by stating their name for the record and be sworn in before testifying. For each witness, the party calling the witness will have the opportunity to examine the witness, followed by the opposing party's cross-examination, and finally an opportunity for redirect examination by the party calling the witness. Commissioners will have an opportunity to ask questions of each witness at the end of their testimony. The petitioner will call and examine their witness first. After the petitioner concludes, the respondent will proceed with their presentation of evidence and witnesses following the same procedures. Parties may present new evidence or witnesses, and if new evidence is introduced, the Commission may remand the matter to the task force for further review. During the hearing, per the enforcement regulations, respondent bears the burden of proving that they did not violate the Sunshine Ordinance as documented by the task force's order of determination and referral. I ask that all commissioners keep any questions they have until the conclusion of each party's presentation, and we'll have opportunity for that later. I'll call on each of you. This is how the hearing will proceed. This hearing will be held in accordance with the Charter of the City and County of San Francisco, the Commission's enforcement regulations, and relevant provisions of the California Administrative Code. As such, the hearing will be subject to the following procedural rules. The hearing is open to the public. The hearing is being recorded, with copies of the recording available on request. The Commission will retain a copy of the recording until all opportunity for legal challenge has been exhausted. Formal and technical rules of evidence do not apply in this hearing. Instead, any relevant evidence will be admitted if it is the sort of evidence on which responsible persons are accustomed to rely in the conduct of serious affairs. Evidence is considered relevant if it has the tendency to prove or disprove any disputed fact that is of consequence to the case. Evidentiary exhibits do not need to be authenticated by a witness with direct knowledge of its content. Rather, evidence will be admitted if it is relevant and meets the standard that I just described. Parties must move to admit any exhibit. Once a party moves to admit an exhibit, an opposing party may object and present their argument for objection, at which point the Commission must determine the admissibility of the exhibit. The Commission has discretion to exclude evidence if its probative value is substantially outweighed by the probability that its admission will necessitate undue consumption of time. The Commission retains the authority to manage proceedings in a time-efficient manner, including by placing limitations on testimony if its probative value is substantially outweighed by undue consumption of time. We will now proceed to the presentation of the case by the petitioner, Mr. Rick Sanders. Mr. Sanders, are you available to speak? Are you in the queue?
Just a reminder, callers, you now have the power to unmute and mute yourself. So, Mr. Sanders, are you there?
I'm here.
Great. You have 10 minutes, and you may choose to reserve 3 of those minutes for rebuttal. Would you like to reserve that time, just so we know as we're timing you?
Yes.
Okay, great. Please proceed.
Yeah, so I opened this public records request in October 2025. This was a request for records relating to the mayor's phone call with the president and subsequent decision to call off the federal deployment to San Francisco, the president's decision. Since then, there's been media coverage about this, including in the SF Standard, where Deputy Chief of the SFPD claims that that the decision was tied to keeping President Trump from deploying the National Guard and ICE to San Francisco, the decision to increase enforcement within the city itself. So there's a significant public interest in these records. The Sunshine Task Force has referred this to the Ethics Commission after finding that the mayor failed to comply with its order of determination requiring a complete response to the public records request. The report shows that, or the referral shows that there was a piecemeal production of responsive records only after multiple Sunshine Task Force hearings, and key categories of reasonably expected records are have still not been released, including a record of the phone call itself. It's a matter of public record that this phone call existed. As a matter of fact, phones retain records of call logs. It is concerning that the mayor's office is not releasing that call log. The only 2 options are that they are refusing to release it, or that it was that record was destroyed. And so I am asking the Ethics Commission to consider this a willful violation. Also, as to the original request here was sent to the public records request email address for the mayor, and it requested specifically records between the mayor and the president. So from my perspective as a petitioner, this is very much about the behavior of the mayor and the mayor's phone and the mayor's records, and very clearly qualifies as a willful refusal to respond to the Sunshine Ordinance. I know that the supplemental documentation that the mayor's office has sent over refers to things like whether or not it's reasonable to request these records, for example, from the phone company, or to create new records, and that is not what is being asked in my original public records request. What is being asked is a release of existing records, of which a call log is, and one would expect there would also be records about the call itself anywhere, whether that is internal notes or communications, any kind of document at all. None of that has been released. And what little has been released, again, has been after a series of Sunshine Task Force meetings. So I respectfully request that the Ethics Commission consider all of this evidence and find that this was a willful violation of the Sunshine Task Force order of determination, and take appropriate action. Thank you.
Thank you, Mr. Sanders. And do we know how long that was, just so that we can keep Mr. Sanders' time?
He had 3.5 minutes.
Okay, great. We will now...
I'm sorry, not including his 3-minute rebuttal.
Right, correct. Great, thank you. We will now proceed to presentation of the case by respondent Mr. Dexter Darmali. Please proceed.
Great.
One moment. Would you like the 3 minutes for your rebuttal, or?
Yes, please.
Okay, thank you.
Good morning, Commissioners. I am Dexter Darmali from the Office of the Mayor. Thank you for the opportunity to be here today, and thank you for the time you spent reviewing this matter. I know the Commission takes these referrals seriously, and so do we. The Mayor's Office is committed to transparency, and we understand the importance of the Sunshine Ordinance in maintaining the public's trust. That said, we believe the enforcement staff has considered the language of the Sunshine Ordinance and has put forth a sensible recommendation. I'd like to briefly review the facts of what happened. The Mayor publicly acknowledged his phone call with the President the day after it occurred, and the call was reflected on his official calendar. When the public records request came in, the Mayor's Office searched for responsive records and produced the public records we had, withholding only communications between the City Attorney's Office and the Mayor's Office that were protected by attorney-client privilege. As the Sunshine Task Force asked additional questions, we took another look. We found scheduling-related text messages related to one of the Mayor's press conferences that should have been included, and we produced them. We also provided additional scheduling records and answered follow-up questions throughout the process. The public records process isn't always perfect and isn't always straightforward. Sometimes a request raises additional questions, or a hearing helps clarify what the requester is looking for. When that happened here, we went back, searched again, and produced additional responsive records. And sometimes there are simply no records. By the end of the task force proceedings, the remaining issue wasn't about public records that the Mayor's Office had and had refused to disclose. Instead, it became a question about whether call logs that might exist with a third-party cell phone provider should have been obtained and produced. But throughout this process, the Mayor's Office produced the responsive records in its possession, asserted attorney-client privilege only when it applied, and continued to cooperate with the task force's review. We appreciate the members of the Sunshine Task Force who spent a great deal of time reviewing this request. There were multiple hearings, a number of thoughtful questions, and a thorough discussion of what records exist and what had been produced. At the end of that process, the task force made a deliberate decision to refer this matter as a non-willful violation. The referral reflects the task force's conclusion that this was not a case of intentional wrongdoing. From our perspective, the record reflects that our office worked to respond to the request, answered every question, corrected an inadvertent admission, and continued producing records as additional responsive materials were identified. Throughout the process, we always sought to produce all available and responsive materials. For those reasons, we respectfully believe this matter does not call for further action by the Commission. We appreciate the Commission's careful consideration of the record, and we respectfully ask that you decline to proceed further with this referral. Thank you.
Thank you. So I now want to check in with Mr. Sanders, and I want to know if his presentation of evidence includes any witness testimony or any additional exhibits that you'd like to admit.
No, I have a rebuttal, but other than that, no additional documents or witnesses.
Okay, thank you. And I will, let's see. I'm going to ask Mr. Dormali the same question about any witnesses or any evidence.
No additional evidence or witnesses.
Okay, great. Okay, so I think now we should proceed with rebuttals. And so, Mr. Sanders, you have the opportunity for your rebuttal now.
Thank you. I mean, notably in the city's response, they said that in response to my October 24th public records request, they, quote, released the responsive records we had. This is very misleading. What they emailed me was, we have withheld records responsive to your request on the basis of attorney-client privilege. Otherwise, we have no responsive records. Please let us know if you have any questions. We now consider this request closed. So they closed it immediately. They did not release any records at all. That's very concerning because later on they did release records that were clearly not withholdable in any way, like just basic scheduling text messages relating to the request that I asked for that would have been found easily if you had opened up the mayor's phone and looked on the date of the phone call and the subsequent press conference that was held about the phone call. Just basic text messages with other city officials scheduling the press conference. So I think that there is a framing here that is very, very misleading. I think that if you look at the record of the public records request, subsequent emails, the original documentation that should have been included with the referral, it's very clear that this was a willful withholding, that what was released was only released after a great deal of energy on the part of the Sunshine Task Force and myself, and that still we do not have basic documentation about this phone call, which any reasonable observer would expect we would have. For example, on an iPhone, there is a call log that is kept when you make or receive a call. Where is that? It has not been released, and the city claims it does not exist. To me, the only logical conclusion there then, if that is true, is that it has been destroyed. Either way, this is a willful refusal to comply with the order of determination, which is to turn these documents over. Thank you.
Thank you, Mr. Sanders. Mr. Dormali, I don't know if you have a rebuttal that you'd like to share.
Thank you, Commissioners. When we received the request, we completed a reasonable and diligent search. This is a very broad request that encompassed an entire city department. As we've said, the process is not always perfect or straightforward, and when we identified additional documents, we produced them. The texts that Mr. Sanders are referencing are not text from the mayor, but text between city staff to coordinate the press conference of city officials to attend the press conference with the mayor. I would also like to correct the statement that information about when this call happened and who was on it and the topic not being provided. That is not true. We produced the mayor's official calendar as required by Prop G, and that includes the date, the time, the attendees, and the topic of the phone call. So that is a public document. Mr. Sanders has that, and that was produced. And I just want to reiterate that this referral is non-willful. The Sunshine Ordinance Task Force made a deliberate decision, knowing the history of being able to refer to the Ethics Commission, and decided to refer this matter as a non-willful violation. Thank you so much.
Thank you very much. So that concludes the party's presentation of this case. Commissioners now have the opportunity to ask questions to each party. I will call on each commissioner in turn, and they will ask their questions to both parties. First to Mr. Sanders, and then to Mr. Darmali. Commissioner Salahi, do you have any questions for either witness?
Yeah, let me start with Mr. Sanders, if that's okay.
Yes, please proceed.
So as I understand it, Section 67.34 requires us to consider willful failures by elected officials, department heads, or other managerial city employees. Which of those is your complaint about?
Could you repeat the list?
Yeah, it's Section 67.34 of the Administrative Code. Talks about the willful failure of any elected official, department head, or other managerial city employee.
Yeah, I think both elected official and department head, given that this request was sent to the mayor's Sunshine request email address, and specifically about the mayor's phone. So from my perspective, that is a request to the mayor as an elected official, and yeah.
So just to clarify, is that the mayor then that you're saying?
Yes.
Willfully failed to discharge the duties? Okay. And then in your presentation, I think you mentioned that you were alleging a willful violation. Is that in the referral from the Sunshine Ordinance Task Force?
That's a question for them. My understanding is that the Ethics Commission can make a decision about whether this is willful or not. From my perspective, it very clearly is, and I can't speak for the reasoning on the part of the Sunshine Task Force.
Okay, and I just want to make sure I understand what the basis for the willful failure is here, because it looks like the task force did conclude there was a failure, at least initially, but is it your position that willfulness is based on the fact that the initial response on October 29th asserted privilege and stated there were no responsive records, and later there turned out to be records? Is that the only basis for that?
No, I would say that is one piece. A second piece is that a series of trivial records were eventually released, but only after repeated hearings. And then finally, and importantly, the call log has still not been released.
Do you have, I should say, proof in the record that there is a call log? Because I understand that the mayor's office has claimed there is not one.
Vice Chair Salahi, I don't mean to interrupt. They can't hear you. If you can speak more into your mic,
thank
please.
you.
Thank you.
Do you have proof in the record that there is a call log? Because the mayor's office, as I understand it, has represented that there is not one.
The proof that there is a call log is the public record, just fact being reported and announced by the mayor himself that he had a phone call on his phone with the president. I don't have access to the president's phone, and it's just a basic logical conclusion.
So it's just the normal record keeping that you expect from a cell phone?
Correct. Yeah. I mean, I think it's just reasonable, very reasonable to assume that, for example, if somebody calls me today, that later today there'll be a record of that call on my phone, unless I, go in and manually remove it for some reason, which I don't know about y'all, but I have never done.
Mm-hmm. Okay, let me make sure I get the timeline right. The call was on what date?
One second. I believe it was Thursday, October 23rd, 2025 is my understanding. Might be the 22nd.
Okay. Thank you.
22nd. And my request was 2 days later.
Those are all my questions for Mr. Sanders. Thank you.
Thank you. Commissioner Francois, do you have any questions?
No.
I think that captures all of my questions. As I'll explain later, I think we're in an interesting posture right now for this case. But this concludes the parties' case in the show cause.
Sorry, we have questions for Mr. Darmali also?
Oh, we do?
Oh, I do.
Oh, you do? You have more?
Yeah, I was
okay.
just talking about Mr.
Oh, okay.
Yeah.
Of course.
Mr. Darmali, thank you for your presentation. I just want to make sure I understand. So the position of the mayor's office is that there are no further responsive records other than communications with the city attorney's office that have been withheld on privilege.
That's correct. And this is about what the request is asking, the date when we received it. Because a lot of this is additional asks that are not part of the original request. And I think that is what this really comes back to. What does the request say? And did we answer the parts of the request that were requesting certain documents?
Just for my benefit, what's the new ask that you say came after the initial request?
The new ask of the task force asked us to go to the cell phone provider and get a log of inbound and outbound calls. But something like that is not within the possession of the mayor's office at the time the request was received, and we see it to be unreasonable to expect the city to go search for private cell phone documents that are not in our possession. How can we give a document that we do not have?
I understand that. What about Mr. Sanders' point about logs that are on the cell phone itself that was used?
We reviewed what public documents we had, and we looked at the request. The request asked for the date and time, and we produced the Prop G calendar, which is the public document giving the date and time.
So I guess is the position that there is no cell phone record of the call, or that it's not responsive to the request as drafted?
I think the better question is, what are the public documents? Because I believe the San Jose case has been referenced multiple times, but that case does not define every document on a private cell phone as a public document. I think that is a larger conversation about what is a public document and what is not.
So it's not that there are no responsive records, it's that the mayor's office doesn't view them as public records subject to the Sunshine Ordinance?
Well, there are no responsive records beyond what we have produced or withheld for attorney-client privilege.
Sorry, I'm just trying to clarify.
Yeah.
I don't mean to put you on the spot. I just want to make sure we're clear, because it's a very different world, I think, for us if there are no responsive records, because that's a representation that you have. And,
right.
But is there no surviving cell phone record on the cell phone of the phone call that just shows a call was made and it was made at this time and it lasted this long?
We searched for those records and we did not find any.
Okay, so that doesn't exist on the mayor's cell phone?
No.
That's all I got.
Thank you.
Commissioner Francois, any questions? I think this now finally concludes, and correct me if I'm wrong, I'm basing this off of what I understand to be the next step. I don't think that we provide Mr. Wolf any additional comment or anybody else any public comment at this point. We conclude, and then we open up for public comment. Is that correct? Yeah. Okay, great. So this concludes the party's case in the show cause hearing in the matter of Rick Sanders versus the office of the mayor. We can entertain a motion at this time, or we can open for public comment and then entertain a motion. Do the commissioners feel one way or the other?
I'd like to hear public comment.
I'd like to hear public comment as well. Okay, any public comment? Anybody in the room would like to offer public comment? Okay, anyone in the queue?
Chair, checking the queue to see if there's anybody for public comment. Looks like we do have one hand raised. We'll give them 1 moment to connect.
Okay, thank you.
Can you hear me now?
Yes, welcome caller. Your 3 minutes starts now.
Great. David Pilpel again. I'm speaking as an individual. Reappointments to the Sunshine Ordinance Task Force have not been made recently. The petitioner, Mr. Sanders, sought records from the mayor's office regarding a matter of great public interest. The mayor's office produced very little information in response to a broad request seeking a variety of records. The task force found violations of the Sunshine Ordinance, held a compliance hearing, and found non-compliance. I urge the Commission to continue the matter today and direct your staff to conduct an investigation here. The task force lacks the authority or staff to do so and could do nothing more than refer the matter to the Commission. It seems likely that additional records exist, including phone logs, staff notes, and preparations for federal troops in the city, which seemed imminent and very troubling. It seems unlikely that a phone call from the president to the mayor would not have staff analysis, note, or reflection before or after. An investigation might confirm that. I believe that last year's action in the Lotaki matter has resulted in court action. I believe that the Commission can avoid or reduce the likelihood of litigation with its own investigation and further proceedings. Finally, this is a referral under Section 67.35D, which does not address willful failure. That is in Section 67.34. Unless you have questions, thank you very much.
Thank you.
I just want to add, just for the record, Zach D'Amico, Deputy Director. I just want to add the commenter mentioned having staff conduct an investigation. Under the Commission's enforcement regulations, certain cases may be handled pursuant to Sections 1 through 9, 12, and 13, which cover investigations and the typical process for an enforcement matter. And the enforcement regulation, Section 10A, gives the Commission the authority to do that for willful violations by elected officials or department heads. So in order to, if you would like to pursue that suggestion, you would have to find that it was a willful violation.
Thank you. It's very helpful.
And Chair Flores-Fanger, I'm checking the queue one more time to see if there's any additional callers. Looks like we do have one hand raised. We'll give them a moment to connect.
Okay.
May I speak again? I'm sorry for the interruption in public comment.
Did you already speak on this item?
This is Member Wolf from the Sunshine Task Force.
Yes, go ahead.
Is this an appropriate time, or do you want me to wait till after the next speaker?
I think this
Are
is
you speaking on agenda item 9?
Yes.
Go ahead. Your 3 minutes starts now.
Okay, great. I just want to add a couple of things. One is, it's a difficult assertion that the respondent makes because they didn't make the attempt to retrieve any additional information, that they can just say they don't have it. So I think the line of questioning around retrieving any additional call logs around on the phone itself, and them not making an attempt to further look for them, and then just to say, well, because we didn't, essentially they're saying we didn't ask the phone company for the call logs or look for the phone log for anywhere else, then we just don't have it. So not making the attempt is not the same as not having it. That's one thing. The other thing is that you do have the ability under, as was just mentioned, to do some investigation. You do have a level of authority that the Sunshine Task Force does not. And that's what we're urging you to do. Lastly, I also want to refer you to the responsibility for administration of the ordinance under Administrative Code Section 6731. It is the responsibility of the mayor to administrate and coordinate the implementation of the provisions of the Sunshine Ordinance, and that may also include a personal responsibility for doing so at that point. So it's not necessarily a reflection on what the task force had brought forward, but that is my reflection to you. Thank you.
Chair Flores-Fang, checking the queue to see if there's any more additional callers. Welcome, caller. Can you hear us?
Yes.
Welcome. Your 3 minutes starts now.
CPRA 7921.005. A state or local agency may not allow another party to control the disclosure of information that is otherwise subject to disclosure pursuant to this division of the California Public Records. The question isn't where the documents are held, it's whether they are pertaining to the business of the public. And you can't just say that because you don't have it, that they are not public records or that they shouldn't be disclosed. Thank you for your time.
Sir, can you identify yourself one moment? I do see his name here. It says Cecil. Chair Flores-Fang, checking the queue. And there are no additional callers regarding this item.
Okay. Thank you. Okay. Colleagues, I'd like to open up discussion on how we would move. I previewed earlier when I sped up a little bit that I think this is an item that I would be inclined to continue. And by continue, I mean I don't feel prepared at this stage to issue, an order or a conclusion on this, given the pending regulations. And I know that there were comments earlier about whether item 11 is actually properly on the agenda. And I hope that our staff can speak to that later. But given where we are and the factual disputes that have been raised and the desire for further investigation, which I agree, I think could be productive here and insightful, I would like to move to continue this, or I don't know if that's the appropriate phrasing, but I'd like to move to continue this until after the enforcement regulations are kind of squared away. So those are my thoughts, but I open the floor to my fellow commissioners to offer their thoughts and propose a motion if they'd like.
I have a question for the city attorney, which is that if this matter is continued and the enforcement regulations are changed in the interim, would the matter be considered under the old version or the new version?
Thank you. So the referral happened under the the current regulation. So I think you actually have to sort of proceed under the current regulations.
Okay.
Yeah, I think
Okay.
that's right.
Well, I'll give my colleagues an opportunity to respond, but that's helpful. I'll revise my motion accordingly.
Mr. D'Amico, earlier you mentioned a provision that guides what you could actually investigate. Could you point us to that? Is that the same 67.34, or is there separate?
No, that's in the enforcement regulations. It's section 10A of the enforcement regulations.
Thank you.
Commissioner Francois.
I really don't feel there's enough information to really make a decision. I'm sorry. Oh, I'm sorry. I thought I had a pretty loud voice, but that's okay. I just don't feel I have enough information to make a decision about this.
Another thing that you could potentially do is to essentially send it back to the Sunshine Ordinance Task Force, which I believe is something you've done in the past around dismissing without prejudice, so that they could send it back with a recommendation or as a willful violation. That would also give you all more time and the opportunity to hear it again in the future if Sunshine Ordinance Task Force sends it back as a willful violation.
And that's because it came in under subparagraph D instead of...
Yeah.
Yeah, okay.
Okay, that's not coming. Anything else from you all? Okay. Well, with that, I mean, I would move to do as you suggest. I was going to say I would move to take no action, as was the recommendation, but I think the action to send it back, to return it to the Sunshine Ordinance Task Force, and then proceed with their new referral, I think would be more appropriate and would give us time to resolve the issues in the other agenda item regarding the regulations. So that would be my motion, but I welcome your thoughts on that.
Yeah, personally, I'm comfortable with that, for the Sunshine Ordinance Task Force to consider whether they have enough information to think that there's a willful violation. I'll say it's not clear to me, based on what is in the record today, that there is one. I understand the skepticism about whether there are additional responsive records that have been withheld, including records on city employees' cell phone reflecting the calls, but we got a representation that they don't exist. So if there are no records, we can't speculate that they're out there, but that could be wrong. So, and then I think the failure to provide a response in the first instance isn't necessarily sufficient by itself to show that it was a willful withholding. So I think that's another area that would have to be developed further to meet a threshold of, us reaching a conclusion that somebody deliberately decided they weren't going to produce anything that they knew existed and was responsive. So I would second your motion.
Should I restate it for the record, or is that good enough?
I wrote it down.
Okay, fantastic. Would you please call the roll?
Certainly. On the motion to return this item to the Sunshine Ordinance Task Force for a future proceeding with a new referral, to proceed with the new referral with more information.
Right. I mean, yeah, with more information and with a determination.
And determination.
Yeah.
Commissioner Francois?
Aye.
Vice Chair Salahi?
Aye.
And Chair Flores-Fang?
Aye.
Chair Flores-Fang, with 3 motions in the affirmative, the motion passes.
Thank you. Agenda item 9 is now closed. Thank you, everybody who appeared for this in person and by phone. I now call agenda item 10, discussion and possible action regarding proposed stipulation, decision and order in the matter of Shimon Walton. I'd like to invite Senior Investigator Bertha Chung to introduce the item.
Good morning, Chair, Forrest Frank, Commissioners. So for the record, my name is Bertha Chang, Senior Investigator of the Enforcement Division of the San Francisco Ethics Commission. So the matter before you today for Agenda Item 10 is a stipulated agreement between the Ethics Commission and respondent, Mr. Shaman Walton, a member of the San Francisco Board of Supervisors. So I'm going to recap a few findings as set forth in the stipulation. So in June 2023, respondent received a painted portrait valued at approximately $5,500 from a nonprofit called Urbanet Academy at an event titled Black Educators Night Out. The portrait was commissioned and paid for by Urbanet Academy and presented in connection with respondents' individual recognition at the event. The evidence establishes that the portrait was intended as a personal gift to respondent, was accepted by him in his individual capacity, and constituted a reportable gift under state law. Because the value of the portrait exceeded the $590 annual gift limit for 2023, respondents' acceptance of the gift violated the relevant provisions in the government code and related regulations. Respondent also failed to report the portrait on his Form 700 for the relevant calendar year 2023, as required for gifts exceeding $50, so that resulted in a separate disclosure violation under the government code. In addition, within 12 months of receiving a gift of travel from Bay Area Community Resources, which are abbreviated as BACR, respondent voted on September 3, 2024, to approve an amendment to a grant agreement involving BACR. The amendment increased and extended BACR city funding. So at the time of the vote, respondent had a financial interest in BACR arising from a gift of travel. BACR was a direct beneficiary of the governmental decision, and it was reasonably foreseeable that the vote would have a material financial effect on BACR. So by participating and voting on BACR grant amendment, respondent violated Government Code Section 87100 and Campaign and Governmental Conduct Code Section 3.206A, which prohibits officials from participating in governmental decisions in which they have a financial interest. So in total, just to summarize, this matter involves 3 violations, and we are recommending the following stipulated penalties for each of them. So for the record, for the first count, we are proposing $500 for acceptance of a gift in excess of the annual gift limit. For the second count, we are recommending $500 for failure to report the gift on Form 700. And for the final count, we are recommending $3,500 for the conflict of interest violations involving the BACR grant vote. So that will amount to a total stipulated penalty of $4,500. Finally, this resolution reflects the seriousness of the violations while taking into account the various mitigating factors that we have fully identified in the stipulation. And this is also consistent with our prior commission precedents. So we therefore respectfully recommend that commissioners to approve the stipulated agreement as presented. Thank you. I'm happy to take up any questions at this point.
Thank you so much. I don't have any questions, but I open up the floor to my colleagues if they have questions.
I have one question, actually, about
Sure.
the penalty amount for count 1. If you could just provide a little bit more explanation as to why it's lower than the value, what you determine to be the value of the gift.
Oh, sure. Thanks, Commissioner Salahi. So the penalty for count 1 reflects commission precedent treating gift limit violations as distinct from the value of the gift itself. Of course, right, obviously, while the portrait's value is relevant to establish a violation, but when we're assessing the penalty, we assess a full range of factors as provided in the enforcement regulations, specifically Section 9D, including things like respondent's intent, benefit derived, comparable cases. So here, I think it's important to stress, and which we also fully disclose in the stipulation, is that staff distinguished this case from cases involving clear, distinct personal financial enrichment. Because although, of course, the gift exceeded the annual gifts limit, the evidence shows that respondent did not receive additional financial gain beyond really the ceremonial nature of the portrait
And he clearly expressed an intent that the artwork would remain with the city upon his termination of the tenure with the city. So taking these factors together, and also, of course, we totally look into prior precedents that the Commission has established before for gift limit violations, absence evidence of concealment or deception or misuse, we determined that 500 is appropriate in the circumstances.
Thank you.
Thank you. I have no further questions for you.
Thank you, Chair.
Is there any, I do want to open it up for public comment, though. So I'm not sure if there's anybody in the room or actually, pardon me.
Yes, thank you very much. James Chafee again.
Sorry, give me 1 second. Pardon me. There is one comment from my fellow commissioner, and then I will open up the floor for your public comment. Sorry that you got up.
I just wanted to mention that I'm a former employee of the San Francisco Unified School District, and he was a member of the Board of Education. And I did work with him while I was with the school district, so I just wanted to have that known with the public. But I have no financial benefit or anything working with him. I just wanted on record that I have worked with him when he was a member of the Board of Education.
Thank you. Yeah, that's appropriate to share. But yeah, without a financial conflict, you don't need to recuse.
Okay. Thank you. Thank you, Deputy Director.
Thank you so much.
Thank you.
Yeah. Mr. Chafee, I know you wanted to provide public comment.
Yes, thank you very much. I have been trying to follow along here. I didn't expect to be commenting on this, and it is something that I believe should be drawn to your attention, even though it's a little bit extraneous. You've provided a packet of documents here which appears to be a little over 200 pages. Most of them are front and back. None of them have dividers indicating the agenda items. There are no page numbers with a table of contents to tell you where one item ends and the next item begins. In this case, Sanders is number 9, and Walton is number 10. In this packet between the two, there's a staff memorandum from August 4th, 2025. There's no indication of whether it's misplaced, why it's there, whether it's part of something or not part of something. It's difficult enough to follow this along without knowing what the documents are or where to find them. Thank you very much.
Thank you. Is that something that our staff would, I mean, this seems atypical. I don't know that we commonly do things like this. I don't know to the extent we want to respond, but I think we're pretty careful in compiling these, and to the extent there's a stray agenda, which I think this may not be a stray agenda, but if anybody from the staff would like to speak to that.
I'm not exactly sure. I'm not on the memo he's speaking of. It may be part of the packet
Right.
if it's information, to a specific item. But it is not something that we would normally do. So
Yeah, thank you for that. Is there anybody else in the public who would like to speak to agenda item 10 specifically? Okay, anyone in the queue?
checking the queue. Give me one moment. And Chair Flores saying there are no callers.
Thank you. Do I hear a motion to approve the proposed stipulation imposing a penalty of $4,500 on Mr. Walton for the acceptance of a gift from a reportable source exceeding the permissible gift limit and failing to report the gift from a reportable source on Form 700, and for conflict of interest.
So moved.
Seconded. Clerk, would you please call the roll?
Certainly. On the motion to approve the proposed stipulation regarding Shaman Walton, Commissioner Francois,
Aye.
Vice Chair Salahi,
Aye.
and Chair Flores-Fang.
Aye.
Chair Flores-Fang, with 3 votes in the affirmative, the motion passes.
Okay, great. Agenda item 10 is now closed. I now call agenda item 11, discussion and possible action on proposed amendments to the Ethics Commission's enforcement regulations. And I would like to invite Senior Investigator Jeff Zumwalt to introduce the item. Oh, 11. I thought we took off 12.
Oh, okay.
Yes.
Earlier public comment on this item. I think if the additional 10-day notice was not
Right. Okay, it was going to be a question, but thank you for
Oh,
addressing
sorry to interrupt
affirmatively.
then.
No, that's fantastic.
Yeah, then I think if in fact there was not the additional 10-day notice, this was noticed a long time ago, but not specifically for this meeting. I think the best course is to move, continue this to another time.
Okay. Well, in light of that, we will be moving agenda item 11 to the next meeting and provide proper notice. I don't know that I have to move to do so. I think I have the authority to do that, but let me know if that's not the case, and I will issue a motion to do that. Great. Okay. So this item is closed. I will. Item 12 has been tabled to a future meeting, as I mentioned much earlier. So we are going to move to agenda item 13, discussion and possible action regarding behested payment waiver legislation. And I'd like to invite Mr. Canning to introduce the item. Thank you.
Thank you, Commissioners. This item regards an ordinance introduced last year by President Mandelman that would change how waivers work for the city's behested payment prohibition. This item was considered by the Commission last October and November, but continued at both meetings to allow for additional consideration. In January of this year, the Commission voted to approve an amended version of this legislation pending the inclusion of a sunset provision. That sunset provision has now been added, and the item is before the Commission again. The addition of the sunset provision is the only change made to the legislation since the Commission last voted in January. Just to review, the legislation before the Commission, as amended, does the following. It allows the Board of Supervisors to grant behested payment waivers to officers and employees of the Board of Supervisors. It specifies that waiver resolutions shall identify the positions the positions of the city employees and officers to whom the waiver would apply, and requires that waiver recipients must report back to the Board of Supervisors about the donations solicited under the waiver within 60 days of the expiration of the waiver, and, as mentioned, establishes the sunset provision specifically for the board's ability to grant waivers to itself, which would expire after 3 years unless amended legislatively by the board and the Ethics Commission. Staff recommends the Commission vote to approve the legislation as amended, as it will give the board greater flexibility to engage in fundraising activities when appropriate, while ensuring all future waivers are more detailed and transparent going forward. Also, the inclusion of the sunset provision requires that the Commission and the board will have a built-in opportunity in 3 years to look back and determine if allowing the board to grant waivers to itself is a practice that the bodies want to continue. If approved by the Commission today, the ordinance would be sent back to the Board of Supervisors, where it would need to be approved by a 2/3 vote to be enacted. If the board were to further amend the ordinance, it would come back to the Commission for further consideration. Thank you, and I'm happy to take any questions. Also, President Mandelman is here available for questions as well. Thank you.
Thank you. I have no specific questions. I don't know if my colleagues would like to hear from Supervisor Mandelman or have any questions, but I don't have any at this moment.
I just have a comment. I want to thank staff and President Mandelman's office for taking the comments that we made at our last discussion about this to heart and making these proposals. And thank you to your staff for making themselves available for any questions that we had leading up to today. So,
I second that. Okay, I'd like to open up for public comment. Anybody in the room? Okay, anybody in the queue?
Chair Flores-Fang checking the queue to see if there's any callers regarding this item. And there are no hands raised.
Great. So the addition of the sunset clause, I think, was my main concern. And so seeing that, I think, has given me great comfort, and I feel comfortable moving forward. And so I'd like to issue a motion to adopt the provision as amended, or the ordinance, sorry, the regulations as amended. Ordinance, thank you. Lots going on today.
And I'll second the chair's motion for the same reason.
Clerk, would you please call the roll?
Certainly. On the motion to adopt the ordinance, Commissioner Francois.
Aye.
Vice Chair Salahi.
Aye.
And Chair Flores-Fang.
Aye.
Chair Flores-Fang, with 3 votes in the affirmative, the motion passes.
Item 13 is now closed. Thank you.
Thank you.
I now call agenda item 14, discussion and possible action on items for future meetings. Do any of my colleagues have anything to add here? I have nothing.
No.
Public comment? Anyone in the room? Okay, if we could check the queue.
Checking the queue to see if there's any callers on this item. And there are no callers, Chair.
Item 14 is now closed. I now call agenda item 15, additional opportunity for general public comment.
Yes, thank you very much, James Chafee again. Actually, under future agenda items, you ought to take up the whole question of how you handle the minutes. You still have the question of the bylaws. If you've looked at the bylaws, there's that phrase, time constraints necessitate. Does that sound like it comes from an appellate court case? Yes, it does. It's 134 Cal. 4th 109. And you won't look, so I will tell you anyway, yes, it's the same James Chafee. Actually, my name is on a number of appellate court cases which define the parameters of sunshine, public records, and open meetings laws. I was an inaugural member of the Sunshine Ordinance Task Force. I was its first vice chair and its second chair. In my working life, I was a paralegal. I worked for Francis McTurnan. Do you remember Francis McTurnan? I worked for Marvin Stender. Actually, I never knew Faye Stender. After that, I worked for a wide spectrum of people, including Duncan Barr, Joel Lamp, Christopher Hampton, Mercedes Gavin, a number of people. Of course, your inspector doesn't know that. All he knows is that I'm an elderly man of declining resources. I probably won't know the difference anyway. I certainly don't have a bar number, so what the heck? Well, the thing is, elder abuse is not supposed to be a cover story. When you tell people that the laws don't apply to them because the words don't apply to them, you're telling them a very heavy thing. You shouldn't realize that, in fact, if I could persuade you of anything, I should persuade you that it's actually worse to tell people that are vulnerable because they don't have other resources that you're not listening to them and that their opinions and circumstances don't matter. They do matter. Of course, the elderly cover story is just the overlying reality. The underlying reality is that the legal profession has destroyed itself. You've decided that you're the nobility and we're the peasants, and that you have to enforce those class barriers by making sure people are not listened to, not understood, and not participants in the society. That's the issue in the complaint that I provided, and apparently it's the same issue with you people.
Thank you.
Chair checking the queue to see if there's any callers on this item. Looks like we have a couple hands raised. We'll wait for the first person to connect.
Sullivan.
Welcome. Your 3 minutes starts now.
There was reference by Mr. Chafee to a packet of other documents that he couldn't make sense of who they were doing. And I take it that these are documents adjacent to the agenda. I do want to point out that section 67.9, agendas and related materials of public records. A, agendas of meetings and any other documents on file with the clerk of the policy body when intended for distribution to all or a majority of all of the members of the policy body in connection with a matter anticipated for discussion or consideration at a public meeting shall be made available to the public. To the extent possible, such documents shall be made available through the policy body's internet site. So you have links that your staff has to their documents, but you should also have links on each of the agenda items to meetings and records and communications from other people outside. Thank you for your time.
Thank you for your comments. Chair Flores Fang, looks like we still have one additional caller. We'll give them a moment to connect.
Can you hear me now?
Yes, welcome. Your 3 minutes starts now.
Great. It's David Pilpel again. I had a couple of brief comments on item 11. I'll address them at this time. Thank you for addressing my earlier comment about the failure to give the 10-day advance notice on item 11. I note that any changes to the regulations do not take effect until 60 days after the Commission transmits them to the Board of Supervisors. So it's entirely possible that the Sunshine Ordinance Task Force might return item 9 to you prior to that time. Finally, the agenda packet materials, as I said earlier, do not include public correspondence on item 11, and nor are there staff responses to the public correspondence. In particular, the Sunshine Ordinance Task Force comments about handling of task force referrals, like item 9 today, are not addressed. So when this item 11 comes back to you at a future meeting, it would be most helpful if the public correspondence is included, staff responses to the public correspondence, and of course the 10-day advance notice. Thank you for listening.
Thank you for your comments. Chair Flores Fang, checking the queue to see if there's any additional callers. And there are no more callers on this item.
Okay.
I can comment on a couple of, if there's interest, I can comment on a couple of the concerns brought up. So all of our agenda materials are posted both online and then are printed and made available at the meetings in person. The materials that are posted online are accompanied by both the supplemental documents submitted by staff and parties and also any public written comment that comes in before a certain deadline. I believe that deadline is Thursday. Anything that comes before, anything that comes after gets added later. And then the other thing I would add is that we do not include written comments submitted from past meetings where something may have been considered. And I think that's maybe what was being referred to. We include all written comment that's submitted for this meeting, but not for the last time something may have been considered months or last year.
And that would have already been available?
Correct. Yes, we would have included it at the time it was considered, yeah.
Great. Helpful. With that, I'll close item 15, and we now call agenda item 16, which is adjournment. Thank you. This concludes the July 10th, 2026 meeting of the San Francisco Ethics Commission.